There's been a new unprecedented development in Steven Donziger's criminal contempt case. According to Donziger, Chevron-associated judge Loretta Preska has ordered that he serve his 6-month sentence in, quote, one of the most unsafe city jails in the country, rather than a low-security federal prison as is customary.
As a reminder, Donziger's unprecedented 6-month sentence is in addition to his ongoing 800-plus day house arrest, which was ruled to be a violation of international law by the United Nations. Steven was charged with criminal contempt for failing to hand over his personal electronic devices to Chevron in their legal counteroffensive against him, which was launched after Donziger successfully sued the oil giant for environmental crimes on behalf of indigenous Ecuadorians. Steven Donziger joins us now to discuss. Welcome back to Rising, Steven.
Thanks for having me.
So talk to us about this latest development. You described this facility that you'd have to serve your sentence in as very unsafe. Can you talk to us a little bit more about that?
Sure. So, this is all part of an effort by Chevron and a federal judge who refused to give me a jury and found me guilty of contempt of court, something I contest and am appealing, to punish me as much as she can. Basically, the broader issue now is whether I have to serve my 6-month sentence before my appeal can be resolved. And I think I have a fabulous appeal. I fully expect to be exonerated. And particularly in a misdemeanor case, this is the lowest level misdemeanor possible in the federal system. It's unheard of for someone to be forced to serve a prison sentence prior to their appeal being heard. But in this case, that's what Judge Preska, Loretta Preska, is trying to do. We're appealing that order right now for the federal appellate court here. But in the meantime, she issued another order, which I find particularly inhumane, which basically says that if the Court of Appeals refuses to let me stay out pending resolution of my appeal of her guilty finding of me, I have to report within 24 hours to the federal marshals. What that does is it short circuits the designation process that the Bureau of Prisons engages in, where they assign you to a federal prison. In my case, it would likely be a very low security prison, given the nature of this low level offense. By forcing me to report within 24 hours, she's likely forcing me into a very difficult situation. That is the Metropolitan Detention Facility in Brooklyn, which is the federal jail in Brooklyn, where, there's been just massive problems with conditions, with lack of safety, with COVID, lack of medical care, lack of infrastructure over the last year or so. So, it would be in a completely inappropriate place to normally put a person in my position. I hope it doesn't happen, but by issuing this order that I have to report within 24 hours rather than just show up like every other person in my position to a designated facility, I think is an attempt to, just put more and more punishment on me and more really gratuitous suffering. So I hope we can get it changed. I hope I don't have to go to prison. That's still an open question, but I just think this order is indicative of sort of what I've been dealing with over the last several years here from these judges who I think are trying to help Chevron.
And the whole thing is just so insane to me. I mean, every single attorney I have asked about whether or not contempt of court would lead them to any sort of jail time at all, they all say, no, I've never heard of this. And for you, you've been under house arrest for over 2 years. For over 2 years now, is that right? You've been under house arrest, and then to actually have to serve prison time, that goes to show that there is something very, very wrong going on here. This whole thing just doesn't smell right at all. And I just really want to get that across to the audience that this is just very, very, very unprecedented and very bizarre. But what is going on with the appeal? I mean, what are your chances? And will you get a different judge? I think that's the big question.
Yeah, I think your question goes to a critically important point. I mean, first is you're right. I've been on house arrest for over 2 years. And I want to emphasize the longest sentence ever given a lawyer who's been convicted of my offense is 90 days of home confinement. Right. I've already served 8 times that amount. And on top of that, she's trying to put me in prison for 6 months. This is just wrong on every level. I think it's a human rights violation, as you pointed out in the intro. The United Nations Working Group has 5 jurists have determined this violates international law in multiple ways, including my detention being arbitrary, and they've ordered me to be released. So, it's wrong on a lot of levels. Now, the question now is like, what do we do about it? So there's a couple of ways to deal with it. I mean, one is, this judge obviously is not changing her position. So we are appealing it, and we do get a 3-judge panel on the federal appeals court. But I want to focus on that for a second. The federal appeals court here in New York has become increasingly conservative. And I have been up to that court multiple times on this case. And I find it extraordinary that they have let my house detention, my house arrest go on for over 2 years on a misdemeanor when there's never been a lawyer who served even 1 day in house arrest for a misdemeanor prior to trial. So I'm really urging that court to look at this seriously. We have our first appeal has been filed on the issue of whether I can stay out of prison pending resolution of the big appeal. And we expect that to be right for ruling starting next week. If they rule against me, again, I'm going to have to go to this very difficult facility, likely in Brooklyn, to start serving my time. The other thing I'd add is I'm 60 years old. It's extraordinary that in light of my age and various health risk factors, among other issues, that Judge Preska would put me into any prison, much less this very, very difficult facility. Now, the final thing I want to say is we are starting a campaign to demand that the United States government, meaning the Biden administration and the Attorney General, Merrick Garland, deal with this United Nations decision. Our country is a signatory to the legal instruments, the Covenant on Civil and Political Rights, the Universal Declaration of Human Rights, that were used to find that my detention is illegal and violates international law. Those laws are binding on the United States of America, and our government has the obligation, we would argue, to make sure I get released immediately. And we are starting a campaign because we've been unable to engage the Department of Justice, although several congresspersons have written them letters. But Merrick Garland needs to do something about this. And there's an easy solution here, which is he simply needs to take back the prosecution so the DOJ controls it. Right now, I'm being prosecuted by a private Chevron law firm, which is, again, extraordinary, and I think explains why I've been under detention for 2 years. Because I have a private Chevron law firm. I have a judge who's linked to Chevron via the Federalist Society, which Chevron funds. And it's important I get a neutral prosecutor and an impartial judge. And I believe if I were to get that, I would be released immediately and the charges would be dismissed. But even if they wouldn't be, I'd at least get a fair hearing from a neutral prosecutor, which I currently do not have. So Merrick Garland needs to step up and take back this prosecution from the private Chevron law firm.
And so Judge Preska, famously said at your sentencing that you needed to be, hit by a proverbial 2x4 so that you would respect the law. What specifically is she trying to get from you in layering on, threat after threat and this violent rhetoric? The broad outlines of directionally what's going on here are clear, but is there something specific? Is she still trying to get access to the electronic devices, or at this point is this just spite?
I think it's the latter clothed in the former, if that makes any sense. I think it is a lot of personal power playing going on by Judge Preska and her colleague, Judge Kaplan. I think they're trying to prove a point with me. I've challenged Chevron. I've challenged some of their rulings, I think, effectively. I've always acted ethically as a lawyer. The order that I turn over my computer is unprecedented. I never said I would never turn it over. I simply appealed the order. But while it was on appeal, Judge Kaplan charged me with criminal contempt of court for appealing his own order. And furthermore, his criminal charge was rejected by the Southern District of New York, the U.S. Attorney. I believe it's baseless, and I believe it's being used as a way to weaponize the law to try to intimidate me as a human rights lawyer who has engaged in some very successful advocacy against Chevron, which resulted in approximately a $10 billion pollution judgment being lodged against the company out of the courts of Ecuador, where Chevron accepted jurisdiction, which has been confirmed by Ecuador's Supreme Court. And I think they're trying to retaliate against me and punish me, so to speak, by engaging in these extraordinary acts of incarceration, first in my home and now in a very dangerous prison. And I will say the United Nations Working Group, again, 5 respected international jurists, ruled the same way. This isn't just me saying this. they ruled this is obviously being done as a reprisal for my successful human rights work. And I want to emphasize, Chevron claims the case in Ecuador is invalid, as does Judge Preska. It's not. It's been affirmed by 6 different appellate courts, including the Supreme Courts of both Ecuador and Canada for enforcement purposes. This is an attempt to lock me up, to prevent me from doing my job as a lawyer, to help my clients in Ecuador who are literally suffering, you cannot believe, because of the effects of oil contamination, enforce the judgment that is a lifeline to the survival of their cultures. I mean, this is 5 indigenous groups and multiple rural farmer communities who are drinking contaminated water literally every day because they can't afford bottled water, because Chevron played God and dumped literally billions of gallons of waste into streams and rivers down there. So they're trying to make a point, I think, to not only prevent, the people of Ecuador from collecting against Chevron, but to try to intimidate other lawyers into not doing this critically important frontline work, which is necessary to hold major polluters accountable, and I think really necessary to save our planet in an age of climate change. So I think there's a game going on here. I think it's corporate power in the judiciary or in parts of our judiciary that are being wielded to try to attack human rights lawyering and attack climate activism.
Yeah, and just so people watching this are aware, we would, of course, be happy to have someone on from Chevron to hear their perspective if they were willing to do that. Steven, thanks so much for being with us. We really appreciate it.
Thank you very much for the opportunity.
Tomorrow on Rising, former National Press Secretary for the Bernie Sanders campaign, Brianna Joy Gray, joins us, and we'll break down all the big stories of the day.
Don't forget to like, share, and subscribe so you never miss a single video, and we'll see you tomorrow.